When the Constitutional Court ruled that government needed to reissue its tender to distribute something like 120 billion rand a year in social grants, many anticipated would be the final word in a very messy matter. The High Court had ruled on this, the Supreme Court had ruled on this, the Constitutional Court has now ruled on it. But the big fight over who distributes South Africa's social grants continues. This is Tonight. I'm Bruce Whitfield. Tonight, I'll find out why it's not the final word. Joining me is the Net1 UEPS Technologies Chief Executive, Serge. Belamant. Before we talk about what you're doing in the Constitutional Court at the moment, let's go back to, is it 3 years already, from the granting of the SASSA tender to Net1.
Correct. 2012,
and you'd gone up against ABSA.
Correct.
Who were also vying for this particular tender.
Correct.
You won the tender.
Correct.
They objected and took the matter to court.
100%.
And they went to the High Court, and the High Court said, we don't like the way the tender was awarded, but you know what, it's been awarded, let sleeping dogs lie. That was essentially how it played out.
What happened, yes. And from then on, of course, it went to the appeals court. The appeals court ruled 100% in our favor, which was quite strange. You know, it was dismissed all ABSA's allegations and arguments. And then, of course, ABSA took it one step further, went to the Constitutional Court, and the whole thing was really ruled according to PAJA. And now that becomes very legalese, which candidly, the PAJA rules are somehow, they're not black and white like we would be in computer science. So it's something which is a little bit more about what constitutes something that is fair, equitable, transparent in terms of a tender. And the argument was around the vagueness of the actual tender, whereby ABSA wasn't able to answer properly in their view because they didn't quite understand what were the requirements. There were some later changes to the actual requirements themselves that created another area of contention or another area of ambiguity. So somebody played on that to say, well, we didn't quite understand what this was all about. And therefore, if we don't understand what it is that we are replying to, how can it be fair and transparent and fair?
Bottom line is the Constitutional Court has now ruled against you and said you shouldn't have received the tender.
Well, it's interesting because when you read the Constitutional Court final paper, which is 40-odd pages, they don't actually necessarily say that we should not be awarded the tender. They say that the process that was followed by SASSA, not by us, we were actually referred to as the innocent bystander, believe it or not. Okay, the process that was followed by SASSA did not meet the PAJA rigorous rules of process.
Okay.
In other words, SASSA did not behave in the way they should have behaved. They did not do all the check and balances that perhaps they should have done, apart from the ambiguity of the actual RFP itself. The court therefore decided to say, there's only one way to do this, let's go back to tender and do it again.
So why not? I mean, you're now going up against the Constitutional Court and saying, hold on a second, but the tender was awarded. We've got the contract. It's a 5-year contract. It's got about 2 years left to run. Let the tender run and then resubmit it to tender.
It's more complicated than that because the reason we're going to the Constitutional Court now is not because of the fact that we want the tender to run for another 2 years. We do not want to have a repeat of the last 3 years. These lawsuits have cost our companies more than $10 million in fees. We were reported to the DOJ that started an investigation on allegations of corruption.
The DOJ, South African Department of Justice,
this is the United States.
Because you're listed in the United States.
100%. We're a NASDAQ listed company. In fact, we're a Florida registered company with an inward listing in South Africa. So we're really a US company. And this created havoc on our share price to our shareholders as well. It cost us a fortune to defend, of course, the action. We've been waiting now, we're waiting for the DOJ for the last 6 to 9 months and nothing has ever happened. We're waiting for the Hawks in South Africa that are also performing the same investigation. And we're hoping that they're going to be finished before the DOJ and actually come out with something to say, either we're guilty of something or we're not. We know we're not. We're waiting for them to actually, for somebody to put it on a piece of paper. So all of this has created havoc with our own company. We do not want to go through another tender whereby if we win it again, and candidly we are the best positioned people to win it, let's be quite honest, what we worried about is that then someone like ABSA are going to come in with the same accusations as they had last time to actually say this tender should actually be cancelled. we can't afford to do this the second time round. Now, what we did is that we had a very good look at the new RFP, the request for proposal. And when we looked at some of the wording that ABSA objected to in the previous one, the word preferable compared to mandatory, for example, which played a big part, there are hundreds of these words in the new RFP. So we're saying already this RFP could be attacked on clarity, ambiguity, contradiction in terms. We're saying, guys, before you ask people to bid, clean it up. Make sure that you get a set of attorneys somewhere or consultants that are going to go through that RFP, are going to write it in a way that is not ambiguous and cannot be attacked. That's one area that we're asking the Constitutional Court to do.
That'll take them 2 years. The bottom line is...
Well, if it takes 2 years, then it takes 2 years. But we don't want to go through this thing again.
But this is a contract worth $2 billion a year. I mean,
it's far less than that. People multiply quickly, but it's $1.5 billion to $1.6 billion. Yeah.
Okay, it's a lot of money that's at stake here.
Of course.
$10 million in legal fees is small change. Why not have the fight?
Well,
relative to what you're earning from it.
Simply because, the Constitutional Court was, to some extent, very much focused on what about the 10 million beneficiaries, and almost said to us, we like an organ of state. In other words, we are really behaving, or we are already in a position whereby we are working for SASSA, and therefore SASSA is an organ of state, so by definition, we're an organ of state. Our job is to make sure that we cannot stop delivering welfare to 10 million people. Otherwise, those people actually die.
Yes.
It's not a question that they can wait.
This is a life and death issue as to whether or not the service is being delivered. The courtroom battle, the drama, the intrigue, the who did what to whom, and the 100%. Wording of the tender is a sideshow to the survival of 10 million people. Yes.
And which the thing that's very important here, no one from day one, no one has ever pointed the finger at Net1 to say you could not deliver. This is the best system ever implemented in this country. That's been now guaranteed, qualified by SASSA themselves.
These are the cards with chip and pin.
With chip and pin, with biometric, linked to the pin, interoperable between the SASSA network and the national payment system. All that has worked perfectly for 3 years.
And may work perfectly, but it goes down to whether or not the tender was awarded fairly and adequately.
100%. That's where we are now. Now it's a question of going through it again. Now what you don't want to do is to now say two things can happen. Either we get audited again, which we believe, candidly, is a very good chance of that, because it's almost impossible for anybody else to step into our shoes in the 3 months that SASSA has given people to do it in. You've got to go and build an infrastructure to service 10,000 rural pay points. You've got to issue 10 million cards. Most people couldn't do that in a year, let alone in 3 months. So we know that we are in a position where, in theory, we should win the next tender. We don't want to win the next tender and immediately being sued and land up in court the very, very next day. Because our shareholders on the other side are saying, well, this tender is for 5 years now, the new one. How long are they going to have it for? Is it going to be 2 years? Is it going to be a year? Is it going to be 18 months? Is it going to be 3 years? The uncertainty then becomes so vast that it's actually not worth our while to have the tender. But it's costing us more money, more time in management bandwidth than the actual the value of it.
The allegations are aimed at you. The allegations are aimed at SASSA by ABSA. If the allegations are spurious and are harming your business, why not take action against ABSA?
We are doing it. We've actually put in a lawsuit against ABSA for the initial things.
Effectively defamatory. If what they say is wrong, it's effectively defamatory.
It's defamatory, 100%. And it's cost us hundreds of millions. Now, one of the things we decided to do is that we filed already a lawsuit against ABSA because of what they had done, specifically the reporting to the DOJ, which candidly, this is a South African issue. This is not an American issue.
But you are an American-listed company,
and
you operate under US law.
But it was a low blow. They could have actually gone to the South African police, the South African DOJ, and sorted it out here.
Would it ever have happened in South Africa, then?
Well, it's happening now because we still have a Hawks investigation. In fact, 3 investigations that are almost been finalized here. So I believe we will get an answer from the Hawks before we will have an answer from the DOJ.
Let's assume you're cleared by the Hawks. Let's assume you're cleared by the Department of Justice in the United States.
Then ABSA is in for a lot of money.
What happens to ABSA?
Well, then we are definitely going to follow through. with our lawsuit, we're going to quantify damages. And because they decided to sue us there, maybe we're going to decide to sue them there as well.
Can you?
Because, of course, because Barclays.
Of course.
Is, why not? You know, they've opened themselves up for a beautiful thing, because there we can sue for damages. You don't have to sue only for what we would be able to sue in South Africa, which is a measly couple of billion. There you can sue for a couple of $1 billion. And at the end of the day, that's what we're waiting for. We're waiting for the clearance, because we know we're going to get the clearance sooner or later to say there was no corruption made by us on anyone. The fact we happen to have better technology, well, we're not even going to apologize for that. We're a technology company. We would expect to have better technology than a bank, who at the end of the day are only users of technology. Let's be quite honest. They don't invent anything. They just implement what other people give them. So certainly we want to go for that. But in the meantime, I think it's completely unfair on SASSA, on ourselves, and candidly on any other bidder, to enter this new tender under even more problematic environment than we had in the previous one. Because candidly, I don't see this tender actually ever getting to the end of it under the current format. And I would be very surprised if ABSA do not believe that the same way that I believe it. In fact, I'm actually surprised that ABSA have not yet either written to SASSA or written to the court to actually put in an objection in exactly the same way as we have. Maybe they would prefer to play the game to actually say, look, we're the nice guys, we don't want to go through court again. This time it's the shoes on the other foot. Before they were the bad people because they were suing us and suing SASSA. Now we're the ones going to court, therefore they can play the nice person to actually say, well, we would prefer not to go to court. I'm positive that they know that this tender is flawed, and I'm also positive that if we win it again, they'll be the first one in court again. We cannot afford that for our company anymore. We cannot do, and the country cannot afford that.
Serge Belamant, thank you very much for coming in and telling your side of the story. Net1's Chief Executive, Dr. Serge Belamant. It's a fascinating tale of intrigue, but at its very core is South Africa's distribution of social grants. If that goes pear-shaped, we've got some serious problems. The corporate battles aside, the corporate battles are fascinating. We'll keep watching those, and thank you for watching. I hope you've enjoyed the discussion. There'll be more tonight, tomorrow. Till then, good night and goodbye.